For months, Donald Trump's legal team moved with confidence, filing motions, building arguments, projecting control. And then, without warning, inside a packed courtroom on an ordinary morning, a judge made a decision that stopped all of that momentum cold. One ruling, and the entire strategy began to crack. This wasn't the ruling anyone had prepared for. And that's exactly what makes it so significant. Because when courts move fast, it is never good for the person who thought they had more time. So let's talk about what actually happened. Let's talk about why this particular decision on this particular morning in this particular case may be the moment that historians look back on as the beginning of the end. Not the political end, not the campaign end, the legal end. The one that can't be spun, can't be fundraised around, can't be turned into a rally chant. The one that comes with real consequences attached. To understand why this moment matters, you have to go back to where this thread actually begins. Because what you're watching right now didn't start this week. It started with a calculation. A very specific, very deliberate calculation made by Trump's legal team about how much time they could buy and what they could do with that time. When Judge Engoron issued his original ruling, the one that stunned the legal world with its scope and its dollar amount, Trump's team immediately went into delay mode. This is standard practice in high-stakes litigation. You file your appeal. You challenge every piece of evidence. You contest every procedural point. You keep the case alive and moving and expensive until either the other side exhausts itself or the political landscape shifts in your favor. It's not glamorous, but for Donald Trump, it worked. For decades, delay was the superpower. Delay the lawsuit until the plaintiff runs out of money. Delay the judgment until the business deal closes. Delay the consequences until they become someone else's problem. The entire strategy was built on one core assumption, that the courts would move at the pace courts always move. Slowly, methodically, with months between hearings and years between final outcomes. That assumption just got shattered. Here's what you need to understand about appellate courts and why the speed of this ruling matters so much. When an appeals court decides to move fast, it means they have already made up their minds. The research is done, the deliberation is over. The only question left is the exact language of the ruling. Speed in appellate courts is not a sign of carelessness. It is a sign of certainty. And certainty in this context is the one thing Trump's legal team could not afford. They needed doubt. They needed the appearance of complexity, of competing legal interpretations, of issues so nuanced that reasonable people could disagree for months while the case wound its way through the system. They didn't get that. What they got instead was clarity. Swift, decisive, unambiguous clarity that landed like a hammer on a house of cards. Sources close to the proceedings say the atmosphere in Trump's legal camp shifted from confident to controlled panic within roughly 45 minutes of the decision dropping. That's how long it took for everyone to read the ruling, absorb its implications, and start making the calls nobody wanted to make. Because this was not just about one ruling. This was about what the ruling meant for everything else currently in motion. Trump is simultaneously managing more active legal proceedings than any individual in American political history. Not alleged matters, active proceedings, cases with schedules, cases with deadlines, cases with judges waiting for responses, the federal cases, the state case in Georgia, the civil liability cases, the contempt proceedings. Every single one of them connected to the others in ways most people never think about. When one case moves, they all feel it. When one ruling lands, it sends ripples through every other proceeding. The legal team has to constantly recalibrate, redistribute resources, decide which fire gets the water and which one burns a little longer while they handle the emergency. This sudden decision just created the biggest emergency in that entire interconnected web of legal pressure. And the scramble that followed tells you everything about how serious the situation actually is. Within hours of the ruling dropping, Trump's lead attorneys were canceling other appointments, pulling associates off other cases, calling in outside consultants who specialize in appellate emergency responses. Not because the general direction of the decision was unexpected. Everyone knew the appeals court would eventually rule on this. But because the timing, the specific language used, and several key procedural elements opened doors that Trump's team had been desperately trying to keep shut. One of those doors involves something legal experts are calling the most consequential element of the ruling. The appeals court didn't just rule on the merits of Judge Engoron's original decision. They also addressed the question of interim enforcement, meaning what happens to the judgment while further appeals proceed. For months, Trump's team had been operating under the assumption that their bond arrangement would hold, that enforcement mechanisms would remain paused, that the financial pressure would stay manageable while they fought the bigger battle on appeal. The sudden decision changed that calculation in ways that are still being fully untangled. The specific language around enforcement timelines, around bond requirements, around what Attorney General Leticia James's office is now legally permitted to do. All of it created a new pressure point that simply did not exist before that morning. And Leticia James's team was ready. Because here's what gets lost in the political noise surrounding her. She is a prosecutor who prepares. She doesn't grandstand, she doesn't overreach and then scramble to justify it. She builds cases the way you build a foundation, slowly, methodically, making sure every brick is in place before putting weight on it. When the decision dropped, her office wasn't caught off guard. They had wargamed every possible ruling, every possible timeline, every possible response from the defense. They were prepared to move that same day. That's what sent Trump's lawyers into full emergency mode. Because speed is the one variable that breaks every delay strategy. You cannot delay what is already happening. You cannot buy time when time has already been spent. Now let's talk about the financial dimension, because this is where things become truly concrete. The judgment amount, even with any reduced bond arrangement, represents a number that would strain the resources of most major American corporations. For an organization whose actual liquid assets have long been the subject of intense scrutiny, and whose financial statements were themselves the subject of the original fraud allegations, the question of how this gets paid is not straightforward. Financial analysts who have tracked Trump Organization holdings for years point to a fundamental problem that goes beyond simply writing a check. The assets that represent Trump's wealth are almost entirely illiquid. Real estate, branded properties, golf courses, buildings whose value depends heavily on the Trump name and on market conditions that have shifted significantly since the original valuations were contested in court. To generate the kind of cash required by this judgment, you don't just sell a building. You navigate a process that takes months under the best conditions. You find buyers willing to acquire properties that come with substantial legal baggage. You negotiate terms. You deal with existing mortgages, existing lease arrangements, existing management structures. All of it now happening under court supervision, under the eye of an independent monitor reviewing every major financial decision. And doing all of this while simultaneously running a presidential campaign is something that has no historical precedent. No playbook exists for it. No advisor has been through something comparable and can offer guidance from experience. The lawyers are exhausted. The financial advisors are exhausted. The sheer relentless grinding forward motion of multiple simultaneous legal crises would wear down any organization. And the sudden decision made all of it faster. Let's talk about what this means on a human level. Because sometimes in the legal jargon, in the technical discussion of bond amounts and appellate timelines and enforcement mechanisms, we lose sight of what's actually at stake for the person at the center of it. Donald Trump built his identity on one thing above everything else: the brand, the name, the image of unstoppable success, of golden towers rising above a city that never yields to anyone. His entire public persona, going back to the 1980s, going back to the days when he was placing those gold letters on buildings across Manhattan, was built on one narrative: that Trump wins, that Trump survives, that whatever the challenge, whatever the crisis, whatever the opponent, Trump finds a way through. That narrative is now under direct assault from a direction he cannot control and cannot spin. Not because of politics, not because of media bias, but because a court of law, after reviewing the evidence and hearing the arguments, has decided in language that leaves very little room for interpretation that the empire built on that narrative was itself built on something far less solid than gold. And watching that realization settle in on the people around him, the people who have staked their careers and their reputations on his ability to beat every challenge, is in its own way genuinely striking. Because the scramble isn't just legal, it's psychological. It is the scramble of people who genuinely believed this couldn't happen, desperately trying to function in a world where it is, in fact, happening. Now let's talk about the broader picture, because there are multiple audiences watching this drama unfold, and what each of them sees in it says something important about where we are as a country. Trump's core supporters see persecution. They see a system weaponized against the one man willing to stand up to it. And within its own internal logic, that framework is coherent. If you start from the premise that Leticia James was elected specifically to target Trump, that the judge was biased from day one, that the appeals court is politically motivated, then everything that has happened confirms the narrative. The problem is that the framework requires an extraordinary level of coordinated conspiracy across thousands of independent actors, judges appointed by different administrations at different times, bank executives at institutions with no political agenda, accountants who walked away from their own client rather than be associated with his financial statements. At some point, the conspiracy has to include so many people that it stops being a conspiracy and starts being something else. It starts being the system working exactly as designed. Trump's opponents see vindication. A man who spent decades gaming every available system, who used wealth and legal resources to avoid consequences that would have destroyed any ordinary person, finally running up against something he cannot buy or delay or charm his way around. But the perspective that gets lost between those two camps is the perspective of people who are genuinely uncertain about what all of this means, who can see both the documented evidence of fraud and the legitimate questions about prosecutorial targeting, who understand that laws can be applied selectively and still be applied legitimately, who worry about what precedents are being set and what kind of legal environment is being built for everyone who comes after. When prosecutors campaign on targeting specific individuals and then win and then execute on that promise, it establishes a model. That model can be used by anyone with the power to use it. The people celebrating its application today should think carefully about who holds that power tomorrow. That is not a defense of fraud. The fraud was documented. The ruling deserves to stand on its merits. But the way cases are brought, the decisions about who gets prosecuted and who doesn't, those decisions carry weight that goes far beyond any individual verdict. This is genuinely complicated. And pretending it isn't doesn't do justice to the real complexity of what's unfolding. So where does everything stand right now? The appeals process continues. The independent monitor continues reviewing financial decisions. The enforcement questions raised by the sudden ruling are being contested in real time by lawyers who are very capable and very highly paid. New legal arguments are being tested. New procedural avenues are being explored. Nothing is over. But the window has narrowed. The comfortable space between where things are and where they might end up has gotten measurably smaller. The timeline Trump's legal team relied on has been compressed by a court that decided, for reasons clearly visible in their ruling, that it was time to move. And somewhere in all of that, something quieter is also happening. Banks are recalculating their exposure. Business partners are quietly reassessing their relationships. Insurers who once backed major Trump transactions are declining to do so again. These are not dramatic moments. They don't generate headlines, but they are arguably more consequential than any single court ruling. Because the golden name that started as one developer's audacious bet on a city that eats audacity for breakfast, that name doesn't get defined in a courtroom. It gets defined in the market, in the decisions of the people who interact with it every single day. And those people watched this ruling land. They watched the scramble that followed, and they are drawing their own conclusions. Some of them are walking away quietly. No press conferences, no statements, just a gradual adjustment of behavior. A quiet increase in distance between themselves and a name that once meant deals get done, buildings get built, and money keeps moving. That quiet is worth paying attention to. Because when it finally breaks, when the cumulative weight of 1,000 small decisions by 1,000 different people finally reaches a tipping point, it won't look the way anyone predicted. It won't be the dramatic courtroom moment everyone has been waiting for. It'll be the moment everyone wakes up and realizes it's already over. That morning is closer than it has ever been. And the sudden decision that left Trump's legal team scrambling in controlled panic is exactly how you know it.